Now, let me here remind that Article 16 of the Charter recognizes a freedom to conduct a business in accordance with union law, not in a void. Thereby, union law is the framework within which a business is to be conducted. Now, thank you very much for this opportunity to deliver some personal remarks in relation to judicial review within the context of the Digital Markets Act. And I would like to ask for your understanding, therefore, if my remarks sound a little bit more theoretical and abstract compared to the excellent presentations we had up to now, I will try to make them as concrete as possible. So, for the purposes of my remarks, I would divide judicial activity in two parts. The first is the competence, it includes the competence of the Court of Justice to deliver preliminary rulings. And in that capacity, the Court of Justice may interpret primary and secondary EU law, but also review the validity of secondary EU law, which includes, of course, the DMA, and relates potentially to any EU law provision that might be applicable in a case before a national court. The second part of judicial activity includes the competence of the General Court and, on appeal, of the Court of Justice to review the legality of secondary EU law. In that capacity, the General Court and the Court of Justice may interpret, but also apply EU law in the context of direct actions for annulment of acts adopted pursuant to the DMA. Now, let me just stop here briefly and say that so far as the review of legality of the DMA itself is concerned, we should bear in mind that the legal basis of the DMA, Article 114 of the treaty, affords considerable discretion to the legislature in order for the latter to make political and economic choices, which it has made in the DMA. That said, those choices must always be based on objective criteria that are appropriate to the aims pursued according to the constant case law of the Court of Justice, and they must be proportionate in the broad sense of this term, as it is further explained in the case law. So far as review of legality of acts adopted on the basis of the DMA, pursuant to the DMA, those include, as of course you know, designation decisions, decisions on non-compliance, decisions ordering interim measures, further specification decisions, if any, and so on and so forth. I would like now to focus on the three interpretation methods applied by the General Court and the Court of Justice routinely in order to carry out their task. First, we have the wording of a provision. Second, the context, legislative and regulatory, of which the provision forms part. And third, the purpose, the aim that is pursued by that provision. Now, all three methods of interpretation are underpinned by, in my submission, by one basic principle, that an act like the DMA imposes obligations that function as limitations to the freedom to conduct a business, as recognized by virtue of Article 16 of the Charter of Fundamental Rights. Now, let me here remind that Article 16 of the Charter recognizes a freedom to conduct a business in accordance with union law, not in a void. Thereby, union law is the framework within which a business is to be conducted. I personally consider that that legal fact arguably gives rise to two intermediary findings. The first is that the wording of a provision imposing an obligation functions as the outer limit of that obligation. The second is that proportionality, the principle of proportionality, shapes the power of the regulator, in this case the Commission, to specify an obligation. That said, proportionality does not function in the same way, depending on whether the Commission will specify an obligation on the basis of Article 8.2, meaning in an individual case, on the one hand, or on the basis of Article 12 by virtue of a delegated act on the other. Why? Because on the one hand, we have an individual act, and on the other hand, in the other case, we have an act of general application. And the case law of the court appears quite clear in how the principle of proportionality works in these two contexts. Let me try and make all these abstract ideas a little bit more concrete. If we take an example, let's say the example of Article 5.2, one could ask oneself whether that provision directly imposes a specific model, directly or indirectly, imposes a specific model on data monetization. Based on the wording of the provision, which is always a starting point, I think we can agree that it does not describe any such model. And we could therefore arguably conclude that any model that does not lead to invalid consent within the meaning of the GDPR can be considered admissible under Article 5.2. So, a more delicate question that we could ask ourselves is whether the Commission can impose such a model by virtue of a delegated act adopted under Article 12.2, and in particular 12.2c. And I think there things get a little bit more complicated, in the sense that the wording of the provision does not seem to preclude such action. However, it does require expressly that any specification on the basis of the delegated act be objectively necessary in order for the gatekeepers to comply with a particular obligation. A second example could be Article 6.4, and one could ask oneself whether a gatekeeper can ask for remuneration within the framework of review of applications or of application stores destined to be side-loaded and therefore run on the gatekeeper's operating system. Again, I would say that starting with the wording of the provision, there is no reference to free of charge, which is quite distinct from, which can be distinguished, which helps distinguish the provision from other provisions that expressly mention free of charge. That said, if we move to a contextual interpretation, taking into account, for example, Article 8.1 or Article 13 on anti-circumvention, one could assume that such remuneration should not include strategic value stemming from the fact that a side-loaded application can run on the gatekeeper's operating system. So that is a more delicate question. A third example I could mention is Article 8.1 itself. Does Article 8.1 mean that gatekeepers are rendered responsible for the ultimate success of the DMA? When Article 8.1 says that compliance should be effective in achieving the objectives of the DMA and of the relevant obligation. What does that mean exactly? Does it mean that the gatekeeper is responsible for the achievement of fairness and contestability? The wording of that provision might suggest so. However, a contextual interpretation, again, taking into account Article 29, which defines non-compliance, will reveal that Article 29 makes no reference to Article 81. It makes reference only to Article 8.2 and to Articles 5, 6, and 7, mainly, so far as non-compliance with substantive obligations is concerned. So those are just some examples of the ways one can approach those provisions and put them in let's say, in the context of the fashion the court drafts its judgments. As a closing remark, I would refer to the fact that the court may be asked to review whether the Commission has complied with procedural guarantees granted to parties by the DMA, always subject to the adoption of a reviewable act, of course. And because we now know that the Commission has specific circumscribed investigative enforcement and monitoring powers, and within those in those powers we also have some procedural guarantees that are granted by the DMA. The court may also review whether the conditions for the adoption of delegated and implementing acts of general application have been complied with when adopting those acts, if that happens, if and when that happens. In respect of non-compliance, the court will, of course, conduct an in-depth review in law and fact of any finding of non-compliance. Court may also exercise its unlimited jurisdiction with regard to pecuniary penalties imposed on the basis of the DMA. And in what appears to me to be a novelty of the DMA, the court may also be asked to review a refusal to accept commitments. If my interpretation of Article 25.3 is correct, which imposes on the Commission the duty to reason the refusal to accept a commitment, that might be an indication that such a refusal is reviewable. Of course, it also appears that the flip side is that if the Commission accepts commitments and those prove ineffective, then the Commission may reopen proceedings for systematic non-compliance, which is, as I understand it, also a novelty of the DMA. So I hope that has been a fairly complete expose of what one could expect within the framework of the court. If there are any questions, if we have time, I don't know.
Thank you very much. Georgios, you didn't have an easy task because you had to think about hypothetical situations in the future about regulations which are not yet being enforced and with zero case to be able to refer to. So really, thank you very much for your contribution.